Welcome to everyone, and thank you to Max and Huwaida for taking time really out of your extremely busy schedules to hold space with us for a little while. My name is Suzanne Adely, and I'm the current president of the National Lawyers Guild, a member of the Bureau of the International Association of Democratic Lawyers, and a member of the Steering Committee of the United States Palestinian Community Network. All three organizations are co-sponsors of this event. So I'm going to shortly pass the mic over to my colleague from the National Lawyers Guild International, Charlotte Keats, to do a little bit of an intro, and then I will introduce the speakers and ask Max to sort of begin to present. I know it's late for you there, Max. Thank you for joining us. And then ask Huwaida to present, and then we will hopefully move into a Q&A portion, and we're going to do our best to give all of you a chance to ask your questions. So please, Charlotte, why don't you go ahead and start?
Great. Thank you so much, Suzanne. And thank you to Max and Huwaida for joining us today for this important discussion and on this critical occasion. And thank you to all of you who have taken the time to come join us today and to be part of this conversation and this discussion about this very important moment for anyone who cares about international law and human rights, and certainly for anybody who cares about addressing the ongoing genocide taking place against the Palestinian people being carried out by the Israeli occupation regime together with, frankly, the United States. And as a US-based legal organization, the National Lawyers Guild sees it as particularly urgent to address this both domestically and internationally. And of course, we know that this is not the only set of war crimes and crimes against humanity for which the United States is responsible. We know that we are gathering today just hours after the United States and the United Kingdom have once again illegally bombed the country of Yemen. The National Lawyers Guild International Committee has just issued a statement, and we intend to continue to pursue organizing, advocacy, and potential legal action to stand with the people in the nation of Yemen against the ongoing bombing and the ongoing attack, which is being justified by protecting shipping to the Israeli regime in the Red Sea. So this kind of attack is one that poses a great danger of broader war in the region, and poses that danger because the United States' power is being threatened. And of course, that threat is coming from the people on the ground who are organizing to defend their rights, their resources, their lives, and their futures. But there is also an important challenge that is taking place legally, and that's what we're going to be discussing today during this meeting. I'm going to turn it over to Suzanne. We've already heard her introduction, and of course, we're thankful to the NLG International Committee, to the International Association of Democratic Lawyers, and to the U.S. Palestinian Community Network for coming together to hold this important forum, a legal and a popular forum, to address South Africa's historic case at The Hague on Gaza, and to discuss our next steps as lawyers, as activists, as legal workers, as law students, and as a movement for justice in Palestine and for justice around the world. Suzanne, please go ahead. Thank you so much.
Thank you, Charlotte. So I'm going to read a portion of the bios for both of our speakers, and then I will share links in the chat so you can read more about them. Beginning with our colleague, Max Boqwana, who's an internationally respected lawyer, having occupied leadership roles in the legal profession, both in South Africa and abroad. Max is the former Secretary General and later became the president of the National Association of Democratic Lawyers of South Africa. And he is a co-chairperson of the Law Society of South Africa for a 3-year term, and a treasurer of the regional body of the SADC Lawyers Association, and currently its president, and has served as a member of the Bureau of the International Association of Democratic Lawyers for many years. He's recently been appointed as the president of the Southern African Development Community Lawyers Association, SADC, and where Max is currently leading 15 bar associations. His focus is on the promotion of the rule of law, human rights, the harmonization of laws, and strengthening the capacity of the various bar associations and their membership. Max is a senior partner at the law firm of Boqwana Burns, based in Johannesburg and Port Elizabeth. He has extensive knowledge and experience in the legal fraternity, boasting considerable experience in litigation, commercial, as well as constitutional law. He is part of the Afrocentric Coalition of Law Firms, African Law Practice, with presence in 8 African countries, where he guides the firm's strategy, talent, identification, and development to share his extensive networks, skill, and experience with younger lawyers. He has been involved in some groundbreaking matters, including the work of the Truth and Reconciliation Commission, as well as various major transactions in and outside of South Africa, and the current work relating to state capture inquiry. We also know, we have collaborated with Max on many important historical international tribunals, looking at everything from police violence of people of African descent in the United States, to the use of sanctions and economic coercive measures. And he's a well-respected colleague of the National Lawyers Guild. So thank you so much, Max, for joining us today.
Thanks a lot, Suzanne. I'm very worried about the bios. I felt like it's a funeral notice.
Okay, so I can quickly read Huwaida's, and then we can just go into.
Let's do that.
Let's do that. Huwaida Arraf is a member of the National Lawyers Guild in Michigan, a Palestinian American attorney and human rights activist. She received her bachelor's degree from the University of Michigan and her Juris Doctor from the American University Washington College of Law, where she focused her studies on international human rights and humanitarian law. Huwaida has been involved in a number of legal and grassroots initiatives for Palestinian rights. In 2001, she co-founded the International Solidarity Movement, a Palestinian-led nonviolent resistance movement, which has twice been nominated for the Nobel Peace Prize. From 2007 to 2008, Huwaida helped build the first accredited clinical legal education program in the Arab world, based at Al-Quds University in Jerusalem. She was one of the initiators and organizers of the first delegation of lawyers to enter Gaza following Operation Cast Lead, and co-authored the report on their findings, Onslaught, Israel's Attack on Gaza, and the Rule of Law. Huwaida is the former chairperson of the Free Gaza movement, and from August to December 2008, led 5 successful sea voyages to the Gaza Strip to confront and challenge Israel's illegal blockade on the 2 million Palestinians living there. I'm going to paste both of their bios into the chat so you all can read more, and then ask Max to begin his presentation.
Susan, thank you very much, and thanks for this kind invite. The presentation by South Africa yesterday. It's actually quite interesting that on the 27th of September 2012, we were part of the ADL delegation that went to Gaza, and to process a number of cases within Gaza. And this use of Article 2 of the Geneva Convention was actually one of the outcomes of our deliberations when we were in Gaza. But I just wanted to admit from the onset that the matter we are dealing with is quite complex, and it's quite convoluted, and it cannot be dealt with through simplistic solutions. It requires our collective thinking, our collective planning, and our collective action. And that's why it's so important to be part of the International Association of Progressive Lawyers, like the group we are dealing with. This is so, in particular, in an environment when the world is devoid of true, genuine, empathetic leadership. So within this context, South Africa sought, as it has done in the past, to play an important role in trying to find a lasting solution to the horrors in Palestine. And in the final analysis, to ensure the implementation of the agreement of the two-state solution based on the 1967 borders. The 75-year illegal occupation of Palestine and the subsequent atrocities as a result thereof are well documented. And I do not want to necessarily go back to that, but this to us in South Africa resonate because it is similar to the struggle against apartheid. And we have understood that the struggle for Palestine is also the struggle for all humanity. So as South Africans, therefore, it's not a surprise that we have acted the way we have acted. So if you are like me, you will understand how it is to live under a settler colonial state, of which Israel is one. The characteristics of a settler colonial state, whether it be South Africa, be the United States, or Israel, is that this group of foreign people occupies the land that belongs to others, and do so by, in many instances, violent displacement, take over their land, force them into the periphery or the reserves. And more than that, the settler colonial state will seek to strip the people of their religion, to strip them of their culture, their language, their names, and in particular their humanity. And in the end, all of these acts justifies their killing. We therefore understood that such people who have been displaced, like the Palestinians, as it was with South Africans, are entitled to resist by all means necessary, and theirs is a just struggle. It will have been important, therefore, that even in the presentations by the South African lawyers yesterday, to juxtapose this idea of a just war versus an unjust war. But the importance of the case is the fact that it has now moved this matter beyond the confines of the court, but engender international discourse on international law and solidarity. Solidarity for us is one of the key instruments that can be used against this type of injustice. And that solidarity that we are talking about is not a solidarity against the state of Israel, not a solidarity against the Jewish people of the world, and against Zionist nationalism, but it is against the illegal occupation, the wanton violence, and the brutality and dehumanizing behavior. And lately, this genocidal behavior characterized by the force that is emitted out by IDF against the civilians, the destruction of the fields and the possibilities of food production, the hampering of the humanitarian access, the combined with violence, mass killing by hunger, and the destruction of medical resources. It's important, therefore, that for many will understand that South Africa, led largely by formerly oppressed Black people, we will recall that during the difficult days of apartheid, both the United States of America and Israel continued to refuse to impose sanctions against that brutal regime. Instead, it continued to assist with provision of arms and helped and abated the continuing violence against the majority of the people of our country. So therefore, it becomes a natural reaction for a government like ours to have taken the stance that it has taken. But also we realize that at the dawn of our own freedom, at the dawn of democracy, we forgot what was happening in the East Africa, in Rwanda. Whilst we were busy celebrating our freedom, there was a genocide that was taking place in that area. And at the end of the day, that genocide is not only blamed on the protagonists, but it is also blamed on the world that was silenced during that time. And that, for us, constituted complicity. We said, therefore, that this time, South Africa is not going to be silenced and is not going to be complicit. Many of our colleagues know that whether it be through the NGOs, like the National Association of Democratic Lawyers that we are part of, and other progressive organizations like the ruling party, the African National Congress, have consistently called out Israel's behavior, either by bringing attention to the Palestinian cause through calling for dialogue for peace and final determination of this conflict. We have joined mass marches, boycotts, and protests. We have sought to use multilateral bodies to continuously highlight the plight of the Palestinian people. We have called for disinvestments and cultural boycotts. The submission, therefore, by South Africa in the ICJ on the 29th of December is the latest of this intervention. And such intervention is important in that it is not only intervention in support of Hamas or any military group, but it is on behalf of the innocent civilians who are collateral victims of this conflict. Toddlers, elderly, the sick, women, and ordinary peasants cannot be regarded as legitimate targets. Understanding that this is a quasi-judicial political matter, and South Africa's stance is therefore that it stands for justice and humanity. The submissions that you have all seen in the 84-page document makes a detailed reference to the Geneva Convention as South Africa being part of the high contracting parties. Israel justifies this by arguing proportionality as a result of the 7th of October attack by Hamas. That South Africa's case is premature, as Israel will have engaged South Africa in a friendly and constructive manner. And also it argues that the acts referred to by South Africa do not fall within the Genocide Convention. At the end of the day, it's for the lawyers to look at that and make a determination whether indeed these procedural defenses are correct. In the end, though, South Africa is asking for a provisional ruling that will ensure humanitarian intervention. And surely there should be no argument about this. But secondly, it's asking this provisional order so that there can be cessation of hostility. We understand the importance of cessation of hostility coming from Africa, because at the present moment, we are a host to 70% of the conflicts around the world. And our knee-jerk reaction in these conflicts is to ask for the silencing of the guns so that we can give an opportunity for negotiations to take place. But the third important aspect of this provisional request from the court is the reality to give us and to give the people of Gaza the possibility to rebuild Gaza, which almost of 80% of it's being destroyed, and create a path towards negotiations and a lasting peace. I think it's important, colleagues, to state unequivocally that the language that is being used, in particular against Palestinian people, is the language that is dehumanizing. People are generally referred to as terrorists. The children and ordinary people are referred to as the shields that are being used by Hamas. In that instance, it justifies their killing because apparently you are not killing human beings, you are killing something else. But it's quite clear that as I'm talking to the lawyers based in the United States, the United States has got an equal, if not more, culpability to what is happening in Palestine, because it will take United States one voice, one meeting to call on Netanyahu and all of these other bloodthirsty people to stop this genocide and proceed necessarily to a lasting peace, which lasting peace of two-state solution is also even a compromise for the Palestinian people. But I think it is important, therefore, that we must call out the United States for its complicity, or even rather the promotion of what is going on. We're quite aware that this is going to have implications, negative and positive. I suspect for South Africa, the implications are that we're going to be receiving a hostile reception, hostile engagement, wherever we have to engage with the West and the United States. But I suspect that this is the price we have to pay for justice. But on the other hand, we are happy with the fact that what South Africa has done has generated interest to galvanize solidarity on behalf of the people of Palestine, but also to excite many lawyers to take interest on this issue of international law, and also to make sure that the students who are teaching, we are exposing them to the matter of the international law. So colleagues, whatever the consequences may be, we as South Africans are determined to raise our voices for the sake of justice and for the sake of common humanity. Thank you very much.
Thank you so much, Max. Huwaida, thank you. Feel free to begin. You're on mute if you're talking.
Oh, sorry. I think after so long of doing these web things, I know better. Thank you, everyone, for being here, for your interest, and obviously for the organizers and for my colleague here, Max. It was a wonderful listening to you. You said a lot of what there is to be said. So I will try to keep my intervention very short so that we can leave most of the time for question and answers. I'm sure a lot of people have a lot of questions as to what comes next. I'll start off by saying that, you know, I was talking, or in my talking to friends these days, probably like many of you, you don't know how to answer the question of how are you? And so I don't even ask it anymore, because those of us specifically that are Palestinian, but I think also broader, anyone who cares about humanity and is watching what has been happening has been horrified and morally devastated at what we have been seeing without any kind of active intervention. And as the brilliant South African legal team said yesterday, this is the first time in history where Palestinians on the ground are live streaming their own genocide in a desperate plea that people will see them and someone will intervene to stop it. And we have seen no one intervene to stop it. And that has been a blow to many people's belief in not only the international legal system, but humanity as a whole. As far as the international legal system is concerned, I think many of us would be rightly critical because it is a system that was devised by imperial powers and has served to benefit imperial powers. It has not done what a legal system, and especially when you talk about international human rights and humanitarian law, are designed to do, and that is to protect the most vulnerable. And the law, specifically international law, has utterly failed to protect the most vulnerable in society when it has come to Palestine and Palestinians, but also when it has come to non-white, non-Western people. And therefore this cynicism when it comes to what even can the law do now is, I think, in its right place. So while this intervention by South Africa was welcome and hailed, and Palestinians, myself included, I think were all collectively not only grateful, but just in tears that this political action would be taken after decades of the world knowing about and watching the brutalization of the Palestinian people is historic and obviously very welcome. A lot of people are cynical as to what can come out of it because the international legal system is so politicized. I think whatever happens, as far as the International Court of Justice is concerned, many people saw the South African delegation's, the legal team's presentation yesterday as really the first time on an international stage in a legal forum, their case heard and so well made, and not just about the genocide that is happening now, but for what has been happening for over 76 years. And for over 76 years, Palestinians' basic rights have not been recognized. What happened during the Nakba has been not even recognized, because any chance or any attempt to challenge that, to demand justice for Palestinians, for the nearly 1 million Palestinians that were killed, displaced, or kicked out, exiled, never able to return. Challenging that was always anti-Semitic, because we are challenging the Israel's right to exist. I won't get into that, but the challenging the existence and the right of any state to exist as a settler colonial state should be something that is unquestionable. We should challenge it. And yet, in this exceptional, seemingly situation, it has been taboo. And yesterday, it was brought out in a way that I think brought all Palestinians to tears, in that what we have been enduring for all of these decades is recognized. Now, what happens is I'm cautiously optimistic, at least at this stage, that provisional protective measures will be ordered, some kind of provisional protective measures, because if there is any hope of the international legal order maintaining its credibility, and this court, the highest court in the world, maintaining a judicial body that's supposed to be non-political, if it fails to order provisional protective measures after the case that has been put before it with more damning evidence of genocide, but even if we don't want to, actually, let me, so I'm clear, to order provisional measures, protective measures, will not be a declaration by the court that there is a genocide being committed, but it would be a recognition by the court that measures are required now in order to prevent further harm until the case can be decided on its full merits. And if the court declines to do that, it will be a very damning statement. And I think the court itself will lose all credibility, because not only was the South African application and its oral presentation of the facts yesterday, but precedent itself, the evidence put forth by UN bodies, different United Nations agencies. And let's remember, the World Court, the International Court of Justice, is the judicial arm of the United Nations. And for the last 3 months, and for the last few decades, we have seen report after report of these UN nations and the UN agencies themselves. And it is very, I think, telling, if you read the report, the application of the of South Africa, it cites and relies heavily on United Nations agencies and reports for that very reason. But all of this evidence, its own precedent, and the level of, you have here a reduced kind of standard that has to be met in order for these provisional measures to be ordered. If with all of that, they don't come back and grant provisional measures, I think that's it for the legitimacy of the court. So I'm cautiously optimistic that at least at this stage, we will get those, and then we'll see going forward. Last thing I'll say before I end, because I did say I didn't want to go on too long, the mobilization of the international community has been tremendous. I know still we feel like it's not enough because the genocide hasn't stopped, but we are moving things. We are the majority, and we just have to keep on. And that this action was taken doesn't mean we stop. That means we escalate, okay? Because justice isn't usually won in the courtrooms. It is the movement on the streets that create the political will that changes the law, that changes how things, that changes unjust laws and brings us to justice. And so the legal arm and the movement in the street, the political mobilization of the people, as it has throughout history, has to continue hand in hand here. And I trust that everyone that is here knows that and continue. And it is a community, all of you, that I'm proud to be a part of. And I believe undoubtedly that justice is coming. It's just when and how many more people need to suffer. And you know, obviously we're working day and night to make sure that justice comes sooner rather than later. So let me stop there, and I hope we have enough time to cover all the questions that have been asked.
Thank you so much, Huwaida.
Yes, thank you so. Oh,
Please.
sorry.
Go ahead, Charlotte. Yeah.
Oh, sorry. Yes, thank you so much, Huwaida. Thank you so much, Max, for these insightful and meaningful comments. I think if you've taken a look at the chat by any chance, there's just been a tremendous outpouring of comments, but also gratitude to both of you for your comments and your remarks. One of the questions that's come up most frequently, and it's come up in the Q&A as well. And it's also one of the questions that we've received kind of the most leading up to this discussion is, you know, what are the chances, as far as both of you see it, that the judges will vote on this case on the merits? We'll be hearing this case on the merits, will act independently, or do we expect that the votes of the judges in the court will be based on the political position of the country that they represent? And that could go in many directions, and in terms of the composition of the court. But I think it would be good to hear both of your analyses on what you expect in terms of the impartiality or lack of such from the ICJ. Max, would you like to go ahead? And then Huwaida?
No. Thanks. Thanks a lot, Charlotte. I've got my own suspicion, and my suspicion is that despite the oath being taken by all of the judges to make a determination of this matter fairly, impartially, and following their conscience, I suspect there will be a great deal of following their political instructions from various countries. And it's a sad state of affairs to think like that, because especially for those of us that come from weak nations, the multilateral institutions and the courts of this nature are very, very important for us as a shield against bullying by the bigger nations. But I suspect, though, if it's not a political decision. These provisional measures will be granted. They make logic. They make sense. They are only humane. And I think that's the important aspect. But despite all of that, I think the point has been made quite clearly into the glare of all of the citizens of the world. It doesn't matter that CNN will not have flighted this, Sky News, BBC will not have flighted this. It's unavoidable that people could see the case that was presented by South Africa, the way Huwaida was saying. So it will have another implication. It will have the implication of reviving this necessary support for Palestine. It also, for the first time, you have Israel glaringly being put on trial. And I think whatever the judges think, the population of the world can make its own determination. Thank you very much.
Thank you, Max. Huwaida?
Yes, I do agree, especially with that last point. In terms of whatever happens, you have Israel that has been put on trial for the crime of genocide. And I think that that is big in and of itself to use in our advocacy, which I talked about towards the end of my comments, which must continue. I am, like I said, cautiously optimistic that at least some provisional measures will be ordered because the facts are irrefutable that there will be harm done. I mean, when you take a look at the number on a daily basis, the destruction, the number of people killed, the journalists, the medical workers, the mothers, the children, the fact that 10 children at least every day lose one or both of their legs. So the case that's put forward about what will happen each and every day that there aren't provisional measures put in place, not only by the brutality of Israel's bombing, but of the crises that UN and other world organizations have been warning of in terms of disease and hunger. The fact that 80% of the world's now cases of famine or severe hunger are in Gaza, and that's the result of a deliberate policy. There needs to be intervention. The UN Secretary General called for intervention. All UN agencies are calling for intervention, and a refusal by the court to order any kind of provisional protective measures will just be damning at the most. I can't even put into words right now what the ramifications of that will be, I think, on a world level, and people's trust in the court or people's faith in the ability of the law to protect them, and what kind of message also this will give to other countries about what they can do and get away with it. And so now, because I'm cautiously optimistic that some, at least, provisional measures will be ordered, that doesn't necessarily mean that the first provisional measure that South Africa is asking for, and that's that Israel suspend its attacks in and on Gaza. That's the number one provisional measures asked for. I think that is a bare minimum, but that one probably will be more of a political calculation. We'll see, but I can't imagine that none will be ordered.
Thank you, Max and Huwaida. I think so. I just want to follow up to those answers with a couple of more questions. I think that you talked about like the hope that the court will look at the merits of the case, and I think that there's been a lot of questions that we've been hearing as to, well, what is actually expected, like, of the judges, right? The judges are the judges actually understood to be doing that, or are they understood to be representing their states, right? And we know that the current president is, of the ICJ is formerly part of the U.S. State Department, and there's a worry about, different ways that that this process can be sabotaged, right? In ways that we're not seeing, that are not transparent. I think also, you know, to this question of the provisional measures, what do we think, even, you know, if we do get the court saying that Israel must suspend its bombing, like, you know, then what does enforcement look like, right? And, you know, because I think that there's a sense that we can't kind of rely on the bodies in place to support that enforcement, and that we have to rely more on like the political pressure and the momentum that such a ruling will give us. But I was hoping that you all could expand on that. And then additionally, you know, there are at least 3 questions having to do with Israel's procedural challenge. And I know, Max, that you already answered some of that in the Q&A feature. But maybe if you'd also like to want to expand on that as well. So.
Yeah, I suggest that maybe then Huwaida can deal with this thing of enforcement, and I think it's common cause that the United Nations has got no police force to enforce orders of this nature. But that court's decision has got a moral persuasion that will have to be followed by the political action. It's quite interesting now that the questions are being raised about the EU. Where is the EU in this thing? And it's interesting further that a country like Belgium has broken ranks, you know, and began to say they are behind the case of South Africa. So it's immediately making a move as far as the political realignment is concerned. But I think both the moral persuasion and the political pressure will be important to make sure that if the court finds in favor of South Africa, that must be enforced. But secondly, it will forever delegitimize the West and the United States to tell people like us about human rights. And I think there's a constant issue that all the leadership of the West come and teach us about human rights in the continent. I don't know what will be their lever going forward if they disrespect this. But in the end, they will also be responsible for total delegitimization of the United Nations as a body. And I'm not sure if the leadership, unless it's really, really crazy, can afford to have that type of blood in their hands. But I think Huwaida can respond better on that part. The earlier point that was raised by Sipiwe relating to what Malcolm Shaw raised in his argument about the demarche that South Africa had sent to Israel, and then South Africa didn't finalize those negotiations, whereas Israel will have engaged possibly constructively or in a friendly manner. There is no obligation on any referring party, firstly, to negotiate and say, then we will go to the court when those negotiations have failed. This argument can only be raised to question South Africa's bona fides in the case, but necessarily you can't dismiss the case on the basis that you should have negotiated. I think as Huwaida was making the point, every minute there's somebody that's dying. And we can't have endless negotiations if there's a possibility of a court intervening. And that's the exigency that needs to be taken. The war is not over. If Israel wants to negotiate a pathway with South Africa, it can still do that even today going forward. Thanks.
Thank you, Max. Huwaida?
Yeah, absolutely. I think this whole procedural point about the existence of a dispute is pathetic, to say the least. I mean, South Africa made clear its position, and it communicated to Israel a number of times that what it was doing was genocidal. And Israel decided, and what to say that there's not a dispute is to say what Israel, doesn't disagree with that. And what would be actually then the procedure? Let's say the court agreed with that. They didn't directly negotiate enough before bringing it to the court. So what? Then there's no prohibition on South Africa refiling the case. So ultimately the court would be saying, you need to talk about it, and then if you don't agree, then come back, which is delaying it. It kind of would be also kind of a blow to the credibility of the court in terms of the remedy. If there was, let's say we agreed with Malcolm in that there was something kind of missing here, the remedy doesn't make sense and it contributes to more harm. So I can't see, this is not a very legitimate or strong argument that they didn't have time to set a meeting to talk about it. There is a dispute. Israel denies that it's committing genocide, that is in violation of the Convention for the Genocide Convention, and South Africa says it is. So to say that there is not a dispute because they didn't meet and talk about it is absolutely ridiculous. And the nature of the convention itself, this is not like any other treaty that you're a party to, so that this is one where you're talking about a threat to the existence of a people, and to then put these kind of procedural hurdles and to give the opportunity of the perpetrator of genocide to delay by saying that we can't meet and talk about it until this date or that date. These delaying tactics would go against the very, I think, essence of what the convention was put in place in order to do. So that I think is kind of, I'm not really worried about that one in terms of protecting the integrity of the convention. But when it comes to the other questions that was asked, right, like the court, how much are they political? We know that they swear an oath not to be. They're not representing their countries necessarily here. They take an oath to decide the issues on the merits. Non-political, but we can't deny obviously that there is political pressure, and how much are susceptible to that we don't really know. Again, if it comes across in their votes that is straightly a political vote, then I think the credibility of the whole court is shot there. We have the UN and we have the Security Council. These are the political, this is where politics plays. In the court, it's not supposed to. And if we see votes come back strictly on political basis, then that would be, as I said before, very damning. That's not to say that there isn't political pressure, as you said, Suzanne, things that we don't necessarily know about yet. But in terms of at this stage where you're not even deciding the actual merits that Israel is in violation of the convention, but that South Africa has made a plausible case of violations, and there is no denying that there's a plausible case that there are violations here, and then that you need protective measures in order to prevent further harm and preserve the rights of the people. That standard, as I said before, is not a very, it's not proof, definite proof. Has a plausible case been made? So I will repeat that I am cautiously optimistic at least some provisional measures will be ordered. Now, I'm going to put forth this other idea that people might rightly be cynical about, but there also is an argument, I think, that maybe even the United States, which is always firmly beside Israel, no matter what, even detriment to the United States' own credibility, but even that they might not be opposed to an order of, demanding that Israel stop its attacks on Gaza. Israel's actions are harming the United States in major ways, harming Biden, and especially now we've entered this election year and he's doing very poorly. So the whole Biden team is relying on people that are upset with him over what he's doing, over this green lighting really and being complicit in genocide. The whole Biden campaign and team are hoping that the anger will die down. And the sooner that the bombing stops, the sooner that can come about. But not that I'm saying people are going to forget. People are absolutely not going to forget. But in terms of the actual thinking of the Biden team. So I actually don't think that they are opposed to the hostilities and stopping. But publicly, they're always standing by Israel. Publicly, in every kind of public space on the political level, they're just always protecting Israel. That is something to consider. But I think the question that a lot of people have been asking is if we get in order for these measures and then Israel doesn't comply. For a couple of things. It will be extremely, even further damaging to Israel, because here they are making their case in front of the court, and then the court rules, and now they're going to say, nope, we're not going to listen. I mean, there's zero justification for that. They throw out all kinds of other things, and they've labeled South Africa as Hamas supporters and all kinds of ridiculous things. But when it comes on, you came into a court, you made your case, and you lost, and now you're saying, I'm not going to abide by the order of this court. It goes a bit beyond all of the other UN resolutions that it did not abide by. It goes beyond not abiding by the 2004 ruling of this court because that was only an advisory opinion. This ruling is binding on Israel. So it will be damning on them. It will be give a lot of activists more to use in terms of our advocacy and just showing what kind of a rogue state Israel is and how it thinks it's above just any kind of law. That I think we can also use, and we should as much as possible. And then in terms of measures to force Israel to comply, yes, the International Court of Justice has no enforcement mechanisms. What South Africa can do then, if Israel doesn't comply, is go to the UN Security Council and ask for enforcement measures through a resolution or whatnot. This is, of course, widely expected to be scuttled by the United States or vetoed if it comes in the form of a resolution. But there is a mechanism then around that, and people may be familiar with the UN General Assembly Resolution 377A, that's the Uniting for Peace resolution, and that is intended to be kind of a mechanism by which the international community of states can bypass the Security Council if there is a state that is repeatedly, through its vetoes, hampering the efforts of the Security Council to actually fulfill its obligations in maintaining a peace, security, and order in the world. And so what that would say is that the General Assembly can vote on the matter. And it has been used twice in the last 3 months. However, it was not effective because something has been missing. The UNGA 377A says that not only can the matter be brought before the General Assembly, but the General Assembly can decide on enforcement mechanisms, even resorting to military force. So the twice before, in October and then I think in December, it was the UN General Assembly took up this issue to bypass the UN Security Council, the failure to order a ceasefire, the US vote in the Security Council. But the resolution brought before the General Assembly did not include, and there was no kind of agreement on enforcement measures. I would say our job now is to pressure our states, those of you mainly outside of the United States, to consider not only voting in favor of an effort that is brought before the General Assembly, but the importance of also deciding on enforcement mechanisms And then also states, sorry, I'll touch on that separately quickly. I know we're running out of time, but enforcement mechanisms can include not only, using military force, but it can include suspending Israel's, participation in the United Nations. It can include sanctions. There's a whole range of things these enforcement mechanisms can, all different kinds of things that can happen, they can agree upon there. But also now, if we have this ruling and under the Genocide Convention, there is an obligation on all states, right, to prevent genocide. And if the court is saying that there is a credible threat that a genocide is being committed here, and there are these measures to prevent it from being committed, then every single state that's signatory to the Genocide Convention has an obligation. So even if it's not done in the UN Security Council, if it's not done in the UN General Assembly, every state then. And there should be pressure also by citizens to suspend also arms trade deals and other kind of businesses to do their job under their obligation under the convention. Sorry, that went on too long.
No, that was excellent. Thank you, Huwaida. I think that like one point that's definitely kind of been brought up, that how this is kind of really a historical moment in which the very integrity of the international legal system is being tested, right? And I think particularly the points that you're making about what's missing from the General Assembly resolutions, and our inability to hold the Security Council accountable for their inaction. And I think there was also a question in the Q&A feature about, well, if these institutions aren't going to be working for us, then what do we need to do? And that's certainly kind of like a matter for future discussion and important, right? Because we have to hold the international legal order accountable if they fail to act, and particularly in a moment like this. And what we're sort of seeing, and I think a lot of us who kind of know the history and trajectory of international law know that the features that we're using to protect human rights, to protect self-determination, that was really fought for by the legal community of the Global South, of the anti-fascist movements in Europe, right? Against sort of the interests of the imperialist powers who've set up international law to protect their own interests. And we're seeing that play out in who is supporting in South Africa's leadership, and who is supporting South Africa, and who is supporting Israel, right? And we wanted to ask a question that's been asked multiple times about, you're thinking about these third-party interventions, right? And we know we have a growing list of states from Latin America and from the Arab world, from the MENA region, and hopefully from Asia as well going forward, stating support for South Africa's complaint, which will hopefully, when it goes into sort of determination about the charges, will equal declarations of intervention should they be useful. And we also hear today that now Germany is announcing their intent to intervene on the part of in support of Israel, right? And then there's also another important third-party aspect that I think that Charlotte can kind of ask, and then and then I think that we also kind of, and then we'll just ask the two of you to comment on that. Charlotte?
Sure, thank you. So one of the questions that's come up in the chat, and I think something that's of interest to a lot of people who are on this call, including lawyers that are engaged in mass defense work, but also non-lawyers that are involved in activism for justice in Palestine, is, would strong provisional measures as they're ordered by the ICJ help to support legal defenses by non-state actors, like, for example, protesters that are confronting Elbit Systems, the largest Israeli arms manufacturer in the UK and the US. There are a series of cases of prosecutions of activists that have taken direct action to confront Elbit Systems. Now, in British courts, they've had access to a kind of a defense of necessity and proportionality, that taking direct action to damage an arms factory is necessary in order to save lives, and that's not a defense that's usually accessible in the United States. But how might an ICJ ruling, even a provisional measures ruling, affect those kinds of cases? But also talking about for example, the actions that Yemen has taken and the role of the Ansar Allah movement, because, you know, the United States and the United Kingdom have repeatedly attempt to declare that the armed forces of Yemen are not representing the Yemeni people. They're only a non-state group, etc. So how might the any kind of a positive ruling from the ICJ affect those states and non-state actors and groups that are actually doing something to put an end to the genocide in Palestine at the same time when the Western states have been silent, complicit, or active participants? And I think we're going to take one more question before we turn it over to you for kind of thoughts on, we know, a wide range of questions here, and I'm going to ask for Marjorie Cohn, who I think both of you know as members of the IADL and members of the National Lawyers Guild, to ask your question to Max and Huwaida as well. Please go ahead, Marjorie.
Yes, thank you, Max and Huwaida, for your really, really critical and excellent remarks. What really struck me about Israel's presentation at the ICJ early this morning is that Israel very briefly said, there's no question that we have the right to self-defense against Hamas. Israel did not deal with the ICJ's ruling in the barrier wall case that said that Article 51, right to self-defense in the UN Charter, has no relevance at all in Palestine because Israel, as the occupier, has no right to self-defense against the Palestinian people who are the occupied. And the test is effective control. So even though Israel pulled its military forces out of Gaza in 2005, it still retains effective control because Israel controls all ingress and egress into Gaza, the airspace, every single thing coming into Gaza, and we're seeing that with the food, the water, the electricity, everything that Israel is blocking. So I think that this is really important for us to keep in mind because we see, especially in the corporate media, just an assumption that Israel has the right to self-defense, and that is not what international law says.
Thank you, Marjorie. Max, would you like to start to address some of those questions?
Yes, no. Thanks a lot, Suzanne. I think Prof is right. The Article 51 makes that point clear that as I was saying earlier on, you're dealing with a settler colonial state, and you can't say you've got a right to self-defense on the people that you are actually occupying and displacing. And I think that's really the rationale behind that provision. But just to come back to a number of questions you have raised, you know, really one of the things one enjoys about this exposition, it's now we are presented with all of this case not through CNN or some mediated process. And there was no shame from the Israel presentation when they say genocide only applies to the Jews. And I think that's essentially what they said, that this Geneva Convention, the Genocide Convention was a promise to the Jews. And it begins to question this idea of humanity. Because if you believe that we all belong to common humanity, that can never be the case. And the presentation goes as far as say, if you apply this Genocide Convention to others, it's going to be turned into an aggressor's charter. Now that's a very bold, arrogant statement, because you are dealing with human beings that are being killed in droves, and many of them innocent. So I think that's the first point. I think Germany on its side, Germany has to come to a point where it has to shake off its guilt of what happened. And both the Germans and Israel, because of what exactly happened during that genocide, they're supposed to be today the crusaders of peace, not the crusaders of the repeat of the never again principle that is sought to be established. And when it comes to this issue of human rights and self-determination, and I think it must apply universally. It must apply equally to the Palestinians, and they've got a right to self-determination. And I don't understand why most of these countries will promote that right to self-determination, as Huwaida was saying, to all the white tribes, the countries that have got white tribes and the countries that don't have white tribes. There has to be a lesser application or a lesser understanding of human rights and self-determination. And I think we need to confront this idea of international racism, because I think it's critical that the fact that you don't see blonde people dying in Palestine, that means these are not real human beings that are dying in that. So I think that's important. But the other action, Susan, I think, we spend quite a lot of time on the Cuban Five. Marjorie knows that. We did extraordinary things. And I remember on the 17th of December, 2015, we were on our way to present the findings of our tribunals in London to the White House. And it was quite interesting that it was on that day that the United States government took a decision to agree to the release of the Cuban Five. We may have to come back to that point and say, shouldn't we begin cases in places like the United States that says, not in our name, that Israel must be protected even under these circumstances, and make it very clear that that population stands for something different. And we find the best way amongst all of these clever lawyers and professors like Marjorie here to be able to put together a case of that nature, and we can build up that case in various countries to support the position that has been taken by South Africa. Most of the cases that we undertook in South Africa during apartheid, they were not the cases that we wanted necessarily to win on merits, but it were the cases that wanted to highlight particular positions. And I think it's time for the activist lawyers and progressive lawyers to begin to do actions of that nature. Thanks, Suzanne.
Thank you, Max. Huwaida?
Yeah, I thank you for all of these questions. I don't know if I can address all of them, but I think the first one was, what would a ruling on provisional measures do to help cases kind of around the world against activists and things like that? I think it would definitely be helpful. I mean, here you have the World Court that has said that there's a credible threat of genocide taking place, and we are doing what we can, our part, to try to stop it. I think it would be very helpful. I don't know if that would work, for example, in the United States, but we do have a case in the United States, the Defense for Children International Palestine versus Biden, and that's a lawsuit by a number of Palestinian organizations and individuals who have lost family against Biden, Blinken, and Austin. And that is currently actually in just under 2 weeks, on the 26th, will be heard in California on the request of that lawsuit, those plaintiffs' request for interim protective measures to be taken. And I think that an order from the World Court could help also in that in that regard. We don't know, obviously, for sure, and politics certainly plays a role in our legal domestic systems. So, but I think it would definitely strengthen the argument and things that we should use in that people everywhere, even if our governments aren't going to do it, people everywhere need to be doing what they can to stop this ongoing genocide. Marjorie, your question is definitely a good one, and it just reminds me that probably people who heard Israel's defense this morning probably recognize that Israel didn't deal with a lot of things being put forward, not only this Article 51 issue, but for example, what it's doing in the West Bank. It didn't kind of address that at all. There's just really no defense for what Israel is doing. In terms of constantly saying defense and a right to defend themselves, I kind of distinguish, like Israel does have a right to defend its citizens, right, to protect their citizens, but any kind of action it takes needs to always be lawful. There needs to be distinction, there needs to be proportionality, and it does not have a right, like what you were talking about, Marjorie, to launch a war and call it a defensive war under Article 51 of the UN Charter. And that is, and the basis and the rationale for that is in the ICJ's own precedent. And therefore, when Israel is saying on the request for provisional measures, saying that the court must not order it to cease its hostilities or just to suspend its operations because it has to defend itself against these threats, I think that that is kind of an obnoxious argument, and anyone that has half a brain can see that what Israel has been, well, first of all, let me clarify, I agree there is no right for Israel to wage a war on an occupied territory and on people that it occupies, for sure. And when it uses self-defense, like defending its people, it has a right to protect its people, but Israel has gone way beyond that, and the evidence was put forward. And there is no, I think the most important point to be made here, and the South African legal team made it, is there is no self-defense argument at all to genocide. Even if an attack was committed on your territory and included like egregious acts, the response to that is not genocide. And the South African legal team made the case for genocide. And I think that that's kind of what we stick to when Israel says self-defense, and the other kind of the straight up kind of argument to that, like even if they had a right to self-defense, that self-defense argument does not give you the right to commit a genocide. And their defense to we are not committing genocide is kind of really obnoxious. It's all Hamas. We heard that over and over again. It's all Hamas. And the other thing they said is that they were doing all they could because they're the most moral kind of army in the world. They take international humanitarian law very seriously, and they're doing what they can to protect civilians, protect them from harm. And obviously we see that that is not true at all. So they did not put forward a good defense at all. And that's why I'll go back to me being cautiously optimistic. If the court is going to have any credibility on what was presented to the court, they need to be ruling on provisional measures. Is there anything else that I missed to comment on? In terms of the actions that the Houthis are taking with the ships kind of in the Red Sea, I don't necessarily know that. I mean, on the political level, and the US-UK airstrikes on it is just kind of obnoxious, and we know why that's being taken and what interest those protect. But whether there will be any kind of effect of an ICJ ruling on that, I'm less optimistic, because obviously we see what powers are taking. That is very political. That's being led by the US and Western powers. And will an ICJ decision then affect them at all in terms of what they do vis-a-vis the Houthis? No, I don't think so. But I'm happy to hear what other people have to say about that.
Thank you, Max and Huwaida. Marjorie, do you want to answer that?
I just want to go back just a moment to self-defense, if I can, and that is that what we see from Israel and what we see in the corporate media is a conflation of the right to use force in the first place, number one, and number two, how is that force used? And I think it's important for us to understand so that we can explain this to people that the first question is the force lawful in the first place? And the answer is no, because Israel does not have a right to self-defense against the people it occupies. Number two, once Israel does start using military force, how is that force used? And Israel is violating not just international humanitarian law by committing war crimes, etc., a whole long list of them, but Israel is committing genocide. So even if Israel did have a right to self-defense against Hamas, which it does not under international law, the ruling of the ICJ itself says that, Israel is using the force that it is using illegally by committing genocide. I think we need to keep those two questions separate and always talk about them separately, because I think it makes it easier for people to understand.
Thank you, Marjorie. And I just want to say,
Oh, sorry.
please go ahead, Huwaida.
I just want to kind of clarify in terms of what I said. I mean, that's true. There is actually an interesting case that we should be expecting a ruling on that's at the ICJ, and that is, but that's an advisory opinion on the legality of Israel's occupation, because occupation in international law, right, it's not illegal. It is a state that is that comes about after international armed conflict. It's envisioned to be temporary until, you know, power is turned over to the rightful sovereign. So it's not really just, but Israel's occupation has gone on for over 56 years. It's not just an occupation. Israel is a settler colonial project. And then so what the ICJ was asked to rule on by the UN General Assembly is whether this has occupation by its nature has gone beyond the legal aspect of the legality of occupation and has become illegal. But when we talk about the right of self-defense, and what I was trying to say is in occupation and occupying power doesn't have the right to use military force, doesn't have a right to launch a war, doesn't have a right to claim self-defense for sure against a people that it occupies. But what I was saying is it has an obligation to its people to keep its people safe, not by doing what it's doing right now. So I just didn't want it to what I said to be kind of misunderstood to try to say that Israel has any kind of right in any way to a self-defense argument. It has a right to protect its citizens.
Right.
Can I just say one more thing in response to what Huwaida said?
Please go ahead.
Yeah, and that is that, yes, Israel has a right to protect its citizens, and the way to do that is end the illegal occupation. That's how Israel must protect its citizens, because but for the illegal occupation, this would not be happening. That's what caused it, and that's the historical context that South Africa couched its argument in, which is critical to understand what's happening now.
Thank you, Marjorie. That's a really important.
I don't disagree with that. Absolutely.
Yeah. Just also, you know, listening to the both of you, it sort of reminds me to also state, even though it's not necessarily directed relevant directly to this ICJ process, but you know, not necessarily the counterpoint, but Palestinians have the right to self-defense. Palestinians have the right to resist under international law. And we had a very good presentation by 3 legal scholars in October on the right to resist under international law, which I encourage people to seek out and listen to. Again, it was extremely informative, their legal analysis and political analysis. So I wanted to maybe then throw out a couple of other questions, and then the two of you can maybe just kind of give closing remarks with that, right? You know, we did receive a lot of questions in the chat, and we tried to summarize them as much as possible. And I think that it would be good to also, you know, answer as a closing the multiple questions about, well, what can we do? Right? What can we do as a legal community? What can we do as movements, right? To either, you know, pressure this process or like impact this process, or act if this process gets sabotaged in any particular way, or act, you know, towards supporting any meaningful enforcement, right? A few weeks ago, actually on the eve of South Africa's application, a new international coalition has formed called the International Coalition to End Genocide in Palestine. And it was set up with the aim of encouraging and putting pressure on states around the world to act to take Israel, to hold Israel accountable to various legal measures, right? And then when South Africa filed, it's kind of really set its main goal as supporting the South Africa's ICJ case. So they issued a statement the day after South Africa's complaint, and within a couple of days, over 1,000 civil society human rights organizations around the world signed it. And so I think, you know, it's really good to sort of contemplate what more can global civil society, global human rights institutions, and popular movements, whether trade unions, what more can they do? And I think, you know, there was also a couple of questions about you know, the impact in the United States, right? And Huwaida, you mentioned the Biden, the charges against Biden and the Biden administration, right, for their aiding and abetting genocide. There was more information revealed today about the direct military support that they were providing in the intercept. We know also that a group of South African lawyers have issued a letter to Biden, also saying that you know, they believe that the Biden administration has been complicit in this genocide, and will be and should expect to be held accountable. And you know, I was wondering if either of you wanted to comment on that. And I wanted to also just give Charlotte an opportunity to also ask one last question, and then also maybe, I know we have the president of the IADL and longtime guild member Jeannie with us to see if she also wanted to ask a question as well. Charlotte?
Sure. Thank you so much, Suzanne, and thank you so much for this, you know, ongoing full discussion. And I think that one of the questions that I know a lot of people have also been bringing forward, and I think this kind of builds on this discussion around the interventions and around this growing campaign and this growing movement, which of course is reflected as Huwaida, you were talking about earlier, these mass actions that we're seeing in the streets everywhere around the world. You know, because of the fact that we can't necessarily rely on the ICJ to rule the right way, and we can't necessarily rely on the UN Security Council to implement a positive decision because, I mean, of the facts and the reality of global politics. So I think there's a question of how can we build forward, especially those of us who are lawyers, legal workers, law students, etc. How can we support the movements that are out there on the streets in terms of, you know, certainly in terms of taking legal action, like we're seeing right now in the ICJ, so like what we're seeing, for example, in US courts in terms of the DCI v. Biden case, the litigation that CCR is working on and others. But how can we help as a legal community to take action on genocide on a popular level, on a grassroots level? How can we put ourselves best at service of those movements? I mean, I think we've seen South Africa do that on a national level at really to the supreme degree in the last couple of days. But what can that mean also for our legal communities here as well? And I see Jeannie is on now if you would like to say a few words or ask a question or make a comment.
Thank you, Charlotte. I don't particularly have a comment, but I do also want to add that with respect to the case against Biden, we have organized all of our IADL members and many people around the world to submit an amicus brief in that case as well. And I think we really do need to think about all the opportunities for mass as well as legal actions.
Just before I, turn it over to Max and Huwaida, I think there's also this question that's come up a lot, and I think it would be great if you're able to include this in your final, in this other round of comments, which is if the ICJ fails to act and or if the Security Council fails to enforce the ICJ's positive ruling, in the case of positive ruling, what will the consequences be for the international legal system? This is, what does that actually mean for the future of the legitimacy of this international legal system, which has already been so incredibly challenged and eroded due to the extreme lack of ability to rein in the war crimes and crimes against humanity of the United States and its allies. But what does that mean for this system? Because that would we have just watched tens of thousands of people be slaughtered in front of the eyes of the world, and the victims of that slaughter doing everything possible on every level to stop it, and people around the world doing everything possible, and states like South Africa doing everything possible to stop it. What will that mean for the future of the international legal system and for the future of the world that we want to see?
Charlotte, before I leave, before other people answer that, I really think that is the crux of what we're addressing today. And I think everybody in the world and the legal community and around the world have very worried about that, because I think it would be such a crisis that it could explode a lot of the legal norms that people really need to have to avoid complete breakdown in the law. So I'll let other people answer that, but that's my view.
Thanks.
Max, would you like to start?
Yes, Susan, I really, the last questions that you guys are raising, it's a critical one. And if ICJ fails to act, and I think all of us, and as lawyers internationally, we must understand that the law depends on its own legitimacy. And I think our responsibility is to do everything possible to make sure that the law is never delegitimized. And secondly, the legitimate law also requires credible institutions, either to pronounce on the judgments or to enforce that law. And I think the responsibility, once again, is to make sure that we promote the credibility of these institutions, including the ICJ. The problem with all of this, if that doesn't succeed, it means the reversal of civilization. So it means then that we go back to arms race, and whoever has got the biggest possession of arms will rule the world, because there will be nothing to mediate these types of international conflicts. And I think that's the biggest challenge that we as progressive lawyers face throughout the world. And I think that's why we need to continuously act, and possibly act the way that we have been doing. And I think, Marjorie, we go back to the issue when we were talking about setting up the academy with IADL. Really, the idea was to promote this idea of international law and international human rights. And I think that's the task that we must not cease in trying to do. And I support the propositions about all the various cases that has to be made. But coming back to practically something else that we need to do, I think those of you that are in the US, and I come back to the point that the two countries that really can help us stop this genocide is the United States and Israel. And I think for me, the upcoming elections in the US, it's important that this matter be made one of the topics about election, in the upcoming elections. And I think we need to make it very clear that we need a leadership that supports human rights, that supports international law. And I think we need to make as much noise as possible about that. And it doesn't stop us to continuously issue statements on everything, including this meeting we're having today, because those that are on the dark side, they must know that we're having these conversations and we're concerned about this matter. And we are ceaseless in making sure that it occupies the agenda of legal and political discourse. But lastly, our important role as lawyers, I mean, the point that Marjorie has explained so clearly, and Huwaida about the self-defense, it's a point that that Israel has been using throughout, and it's a false point. Then what it means is that the responsibility of lawyers is to clarify these very, very important points to other NGOs, to the other activist organizations, and also in the end, even use them in terms of propagation of cases that can be taken. But as I was saying at the beginning, the matter we're dealing with is very old, is very complex, is very convoluted, and we are finding ourselves in a world that have got no inspirational leaders, that have got no leaders who are inspired by humanity. And I think it's critical that we continuously call for that. But as far as the issue of solidarity with the Palestinian people, and that's the thing we must be firm about and continue to work on. Thank you very much.
Thank you so much, Max. Huwaida.
Yeah, so many critical questions. Let me start with, you mentioned that there were a group of South African lawyers who warned Biden that they were going to sue. I honestly didn't understand from their letter what their intention was, because they can't take Biden to the International Court of Justice, right? That's a state by state thing. They can't. I think the only forums that they could sue in is using universal jurisdiction in various countries. So you can hold committers of war crimes and crimes against humanity and people aiding and abetting those liable in various countries using universal jurisdiction. And Palestinians have actually, there have been a number of cases over the years attempting to use universal jurisdiction to hold Israeli war criminals liable. And what ended up happening, if any of you guys remember, this is going back to the early 2000s, is a number of countries unfortunately changed their own domestic laws in order to preclude lawsuits against Israel based on, they kind of just made it more difficult, saying there needs to be a nexus with the state, which wasn't there before. And it really dilutes the point of universal jurisdiction, which is that there are crimes that are so heinous that people have and countries have an obligation to hold the perpetrators accountable. And so there was an attempt in Belgium, in Spain, and in the UK, and all of these changed their internal laws to say there needs to be a direct nexus with the country, and therefore they shut down the cases against Israeli war criminals. I think now, even with the changed laws, something that lawyers can do in other countries is use their universal jurisdiction laws, because now, considering the massive death toll and destruction in Gaza, and Palestinians who are living all over the world, in the United States, in the state that I'm in, Michigan alone, we have Palestinians who have lost dozens of family members. So, and these Palestinians all over the world in these countries that change their universal jurisdiction laws, in Spain, in the UK, in Belgium, and in other countries, I would assume that lawyers will probably start looking into that. So even with the revised laws, that now they still can use it because there is a nexus. Their own citizens who are Palestinians and who've lost family and property in Gaza should be able to file lawsuits. Other things that lawyers can do is, as we know, especially in the United States, but around the world, extreme repression against people who are advocating and speaking up for Palestinian rights. And so we need people, lawyers, law students, to be kind of volunteering as much as possible to take on some of these cases. We know the Palestine Legal takes on a lot of them. Palestine Legal is a very small organization. The National Lawyers Guild assists. There's the Arab American Anti-Discrimination Committee, but these institutions, these legal bodies or firms that exist to kind of do that are overwhelmed because the repression has been so great. So I think that lawyers can also make their services available to protect people, or to file lawsuits on behalf of people that are facing repression for their advocacy for Palestinian rights. I think that there are, unfortunately now, but there is a lot of need for lawyers and for people who are interested in this area of work. But as people, non-lawyers or people who want to continue advocating, irrespective of what the ICJ decision is and what enforceability is, yes, we continue taking to the streets, but we know of the global boycott, divestment, sanctions movement, which we must continue strongly. And I think this case being brought before the ICJ and just what we have witnessed and what is readily available in terms of the mass atrocities that Israel has been committing should strengthen our cases for boycott, divestment, and sanctions. So we do that as much as possible. I think that the big question, and Jeannie kind of really said it in terms of it's a big dilemma. Like, how do we actually make international law apply equally and not just continue to be a tool of Western kind of colonial and powers and imperialism? Because we see the institutions that are currently in place. I mean, though we do have laws, they don't work equally to protect everyone, and they have failed to protect the most vulnerable. And I would say that there is work on that on the international level. I'm not directly involved, but I think we all have a role to play in pushing the development of that law. One of the things that we have been hearing about, especially because the United States has been vetoing resolutions in the Security Council, is the whole existence, not only the Security Council, but specifically the permanent 5 members that have veto power, that needs to change. We've been hearing more about that, and I hope that picks up, because that indeed is one of the things that needs to change in order to change this dynamic where it's only the political will is only there to hold certain countries liable and not others, and others can act with impunity. So there needs to be continued work on that. The non-aligned movement, on an international level, and there always have been, I think, on a practical and academic level, putting forward some proposals and papers on this. And I think that we just need to build on that, because the system needs to be one that actually that people can believe in, will protect them also, and not based on what country they're a national of, or the color of their skin. Finally, I think I want to say, I talked a little bit about before the obligation of Israel and when it uses self-defense and all of these things. That's looking at Israel as a state, and a state has an obligation and a responsibility to protect its citizens, right? Okay, that's something that is recognized in the law. But what is less looked at is that not only, Israel is an occupying power, Israel has actually has an obligation, not only under the rules of law to, distinguish and whatnot. It actually has an obligation to the people that it occupies to protect them and to make sure that they are able to carry out kind of a normal life. They are the ones controlling the territory. They are in power. And just like Israel has a responsibility to protect its own citizens, it has a responsibility to protect the people that it occupies. And that I don't think we have heard much about. But I wanted to take it beyond that, because we look at kind of Israel's obligation to the state, and now we hear a lot about the two-state solution, or what the future can be. And I would just, my view is that as much as every time we hear a two-state solution, we should fight back against that, not only because it is impractical now, but because it does not take into consideration that Israel is founded and continues to exist as a settler colonial apartheid state, and that needs to be dismantled. So let's not talk about creating two states when one was founded and for decades has been and continues to implement policies in service of maintaining that superiority and that domination. And one of the things that is done in the service of, settler colonialism is genocide, to get rid of and to replace the indigenous population, right? So that is also the context that we're in. But I say that because when we're looking at the states now, and especially the United States and whatnot, if they want to talk a lot about the day after and what after Gaza, and you're hearing a lot about the two-state solution, and that is never adequate because that doesn't address the fact of what Israel, how it exists now. It is given legitimacy, unfortunately, but one of the ways that we continue to fight back is to emphasize the nature of the state that exists and how that is illegitimate, and that we have to, in order to have any kind of future and peace and security for people, that we have to start first by dismantling that structure, that dismantling colonialism, dismantling the apartheid system that is in place. And I only raise that and to end with that because we do hear a lot now about, what comes next, and we want to work towards two states, and that is not workable. And I don't think that is, I think that we need to kind of continue to fight back against it in terms of what we're actually dealing with here. We're not dealing with like a territorial dispute between, two states and two parties. We are dealing with a settler colonial project that has inflicted massive death and destruction and has deprived the Palestinian people of their basic rights for 8 decades. And that needs a resolution, and a resolution starts with recognizing what the problem is and dismantling that, and then we move forward.
Very well stated, Huwaida. Thank you. Margie, did you want to make a comment?
Yes, just briefly, Huwaida mentioned universal jurisdiction as a way for individual states to hold the leaders, officials, military of Israel and the U.S. accountable. But in addition, the International Criminal Court, under the Rome Statute, can prosecute leaders of countries and should be. But there's a difference between the International Criminal Court and the International Court of Justice. The International Court of Justice resolves disputes between states, between countries. The International Criminal Court is an actual criminal court that can prosecute individuals. And even though there's been a formal investigation of Israel's war crimes and crimes against humanity in Gaza for almost 3 years now, because of the pressure from the United States and other Western countries, the court has become very politicized, and the current chief prosecutor is dragging his feet. Now, if the ICJ were to determine that Israel is committing genocide in Palestine, that finding of genocide would bind the International Criminal Court, which would not have to determine whether genocide is happening, but would put pressure on it to identify individual leaders to arrest and prosecute. And so, in effect, what a finding of genocide by the ICJ would do is to provide political cover to the ICC to do its job, which is to prosecute leaders of Israel and the U.S. And so it would have to say to its patrons, the U.S. and others that pressure it and threaten it, hey, the ICJ found genocide. We are now bound to bring criminal charges against these officials.
Thank you, Marjorie. Charlotte, do you want to help us close this out?
Sure. Thank you so much, Suzanne. And thank you so much, Max and Huwaida, for your powerful words. Thanks to the over 200 of you who stayed on this webinar for nearly 2 hours to discuss these issues. And of course, thanks to Marjorie and Jeannie for your comments and interventions as part of this project and as part of the IADL and the National Lawyers Guild as a whole. And of course, thanks to the U.S. Palestinian Community Network, National Lawyers Guild International Committee, and IADL for organizing this event. And of course, Suzanne, for your facilitation of this, but also for your ongoing leadership in the U.S. and international legal community on Palestinian liberation and holding Zionism and imperialism accountable for their crimes and crimes against humanity. I think that moving forward from this discussion, this is just the beginning of a very important discussion and a very important conversation, that it also has to be combined with action. And this will include working to make sure that there are strong interventions from a number of countries following the preliminary measures phase of this proceeding to provide a strong counterweight to the voices of the colonial powers, like, for example, Germany, or like the State Department's John Kirby, who attempts to, label an 84-page extensively researched and well-argued document as meritless and groundless, and to dismiss it out of hand with the confidence of an imperial sovereign that feels that it will never be challenged. So it's critical for us to be out there organizing to make sure that there are strong interventions and to support the rising clear voices of the people of the world, particularly of the global South, that are continuing to resist and fight back and organize. And that includes from those who are organizing and resisting today on the ground in Palestine, in Yemen, who have come out in 1 million people today to march despite the US and UK's bombs just last night, to insist that their bond with Palestine will never be broken. Everyone throughout the region and around the world that are continuing, including in our own cities and communities, there are hundreds, if not thousands, of actions taking place in cities around the world this Friday, Saturday, and Sunday for Palestinian liberation. Please come out, join those actions, and organize, because we need to resist on all fronts, to stand with the people of Palestine, of Yemen, of Lebanon, and of all people that are being threatened by and are fighting against imperialism and colonialism and the Zionist regime in Palestine. And just to say in conclusion that this year, as part of its annual process of elections and resolutions, the National Lawyers Guild adopted what is really a very important resolution regarding its own history and its future on Palestine. In 1948, the National Lawyers Guild applauded the creation of the State of Israel and called for the United States to remove any barriers to the sending of weapons to Israel, and to fund and support that colonial project in Palestine. And that reflected a huge colonial blind spot on the part of the left in the United States at that time. And this year, the National Lawyers Guild officially adopted a resolution apologizing for and rescinding those initial resolutions to continue on the process that it has been part of since the 1970s of exposing the war crimes and the crimes against humanity of the Israeli occupation regime, and to defend the Palestinian people and the right to resist and to fight back against the United States's role in continually funding and supporting this genocide. So this is just one indication in one movement of the transition that has taken place in the past 75 years. Now, of course, the tragedy of that and the crime of that is that that transition has taken place over the bodies and the lives of Palestinians who have been killed, expelled from their homelands, denied their right to return for the past 75 years, face constant settlement building, land confiscation, home demolitions, mass imprisonment, and all of the crimes of settler colonialism on an ongoing and daily basis, including this current genocide taking place against the Palestinian people centered in Gaza. But it reflects the growing sentiment, but also willingness to take action of people, movements, and organizations around the world to finally put an end in an increasingly multipolar world, to put an end to these crimes and to no longer stay silent while they continue, in our names, with our tax dollars, and with the full participation of our governments. So thank you again to all of you for being part of this discussion today. We look forward to continuing these conversations. And of course, salutes to Suzanne, Max, Huwaida, and everyone who's been part of the conversation today. And salutes to the people of South Africa who have fought back against apartheid and colonialism and are fighting back in the courts today, to the people of Yemen who have refused to be silenced or to bow down in submission after nearly 10 years of colonial war by US proxies. And of course, to the people of Palestine who continue to resist, to live, to fight for return, to struggle for liberation in Gaza and everywhere in occupied Palestine and everywhere in exile and diaspora. The future of a free Palestine is a future for a free humanity for all of us. So thank you again, and the struggle will continue until victory, liberation, and return.
Thank you.
Thank you, guys. All the best.
Thank you so much, Max. Thank you so much, Huwaida.
My
Enjoy your
pleasure,
call.
man.
Thank you all.
Great meeting you, Huwaida.
And thank
Same.
you, Marjorie. Those were really useful interventions.
Thanks.
Thank you.